Thank you. Thank you so much, Amy, Mike, David. Where are you, David? Did you already leave? David, when you said rock star, I don't know if you saw me. I was about to stand up, and then I leaned right back. I thought that was for me. But it just sounds so good coming out of your voice, rock star. I mean, I liked it. So I want to introduce myself. I'm Tony Romanucci, and I'm an attorney here in Chicago. And I think one of the reasons why I am here is the reason why I'm wearing this pin on my lapel. If you get to know me, you'll see that I typically do wear a lapel pin, and it'll change. It'll either be this pin here, which represents the Illinois Trial Lawyers Association. It will be a pin that represents one of my two favorite charities that involve children, either St. Jude's or the Lymphoma Association dedicated to cancer. Or it will be a pin that one other individual I saw was wearing here tonight, which is a 7 pin. And if you look at it, you can stand up. You want to show him your pin. Our erstwhile trial lawyer from Kentucky, he's wearing a 7 pin that looks a little bit like a question mark. And there's a reason for that. There's a reason for the way why that 7 is shaped in that way. And that is because you're supposed to ask, what is that? Because it looks a little bit like a question mark. It looks a little bit like a 7. You're not really sure what it is. But that 7 means something very, very important, not only to me, but to many of the people in this room, because that 7 is access to justice. That 7 represents the 7th Amendment, the right to a civil jury trial. And for myself, a trial lawyer in the city, and I could go around this room and have all the trial lawyers stand up, that's what we believe in. So I want to tell you a story of how strong our beliefs are, because you need to understand from a trial lawyer's perspective, and it doesn't matter who you are here, but it's very important that you understand what a trial lawyer is and what our raison d'etre really is. And the reason it's important for you to understand where we come from is because we live in a democratic society. And our beliefs and views are shaped in one way. And we invite discussion from your different beliefs, because it is from those discussions that we are able to move forward and live in a democratic society, as opposed to an adversarial one where someone lives in lies or tells lies or not. So the story I want to tell you is one that I experienced last week in New Orleans. I was at a conference there. And it was one of my jobs as one of my positions in the American Association for Justice, which is known as AAJ. That's the national equivalent of what the Illinois Trial Lawyers Association is. And at AAJ, I was tasked with meeting a senatorial candidate from Kansas by the name of Barbara Bollier. You may or may not hear from her in the future. We're hoping that she wins, but that's not the point of this. This is not a politicized speech. I just want to tell you who it is that we are and why we are so strong in our beliefs. So I asked Barbara, because I could call her that because she's not a senator yet. I said, Barbara, how many times have you met with attorneys as you have here in New Orleans? And there's a lot of them there. There's like 1,500 attorneys, not just 50 or 40 that are in this room. She goes, well, I've only had one other meeting, and that was at the State Bar Association, and that was a while ago. I go, well, let me tell you what to be prepared for here. I go, you are going to be meeting, you're going to be introducing yourself tonight to lawyers who are ideologues. They believe in one thing. They believe in access to justice. Because if we know that we have the ability to bring our client's case to a courtroom before a jury, that we have the opportunity to complete and close the loop for why they came to us in the first place. Because they were harmed by a wrong, by a tort, by an act of negligence. I said, if you are able to communicate your belief that you believe in the 7th Amendment and that access to courts and to justice, you will win the room over. If you don't communicate it, there's no gray area here. We don't see things in between. That's what we believe in. Now, here's the interesting thing about Barbara Boyer, if anybody knows her background. Guess what she is? She's an MD. She's a doctor. And as I was talking to her, she put her hand over her heart. And she says, Tony, that is what I believe in. She's a human who believes that other humans have the right to their day in court. And that's what we do. So when people say, what does ITLA do? What do the Illinois Trial Lawyers Association do? Well, I don't tell a story as long as this. I tell it now to you in this length because I'm given the chance to. But that's what we do. We try to close the loop on a wrong that one of our clients suffered. And you're going to hear from some great lawyers today. I mean, really, really great lawyers. Probably the greatest in the city of Chicago is sitting right to my right here, Pat Salvi. And his son is here too, Pat Salvi too. And there are other lawyers that you're going to hear from. And you're going to hear from them as to what they've done to maximize recovery from their clients when they've taken their clients' cases to court and how they've won. So that, in a nutshell, is what ITLA does. And I can tell you, I am super proud. I am very honored to be able to say and introduce myself as being a trial lawyer. There's no shame, there's no embarrassment to it. I shouldn't hide from it. I never will, because that's what I do. I ultimately, if we don't succeed in resolving the case by way of settlement, we take the case to court. We let a jury decide. That's our system of justice. You know, one last thing, then I want to turn it over to Matt, because he's got some important updates to tell you about his field of litigation. When we are at trial, and either sometimes before or sometimes afterwards, depending on what the judge is thinking or what he or she wants to do, that judge will tell the jury to empower them, to energize them, which is a little bit of what I hope I'm doing for you, because you're not going to learn from me. You're not learning as to what I'm telling you. I'm hoping to energize you in our beliefs that this is our system of justice. That judge will tell the jury, ladies and gentlemen, thank you for your service. I know that the lawyers are honored to have had you on the jury. You know that the victim is honored to that you've heard the case, you've listened to all the evidence. And remember, this is the only country in the world where you are guaranteed the constitutional right to a trial. Isn't that amazing? You think about that. This is the only country in the world. We're not talking about criminal trial. We're talking about the Seventh Amendment. Nowhere else in the world. And we have that right, and we aim to keep it. Thank you.
Thank you, Tony, and thank you, Amy, and all the folks here at Exigent. I'm honored to even share a stage for a moment with someone like Tony Romanucci. I mean, this guy's a legend. I'm like, hopefully someday going to be at that level. But I'm here, and I want to pick up on his theme. My name's Matt Adair, and I practice in the field of asbestos litigation, representing clients with mesothelioma. And I'm at the firm Cooney and Conway. I've been there for about 10 years. And to Tony's point, today, as we are here in this room right now, there are 5 attorneys from my office that are on trial, and they're going up against one of the biggest auto manufacturers and auto brands in the world. And these companies have unlimited resources. They have very good lawyers. And I'm proud of my colleagues for continuing this fight that Tony mentioned. When we have a case that goes to trial, just to put it in perspective, I mentioned we have 5 attorneys that are on the case. They've been in court. Every day for the last week and a week before that. The trial will probably go on for another 2 weeks. There's going to be 8 different expert witnesses called, and I know a lot of people in this room are familiar with how important experts are to prevailing at trial. Not to mention that the other attorneys at my office and the staff members that are on call for the next couple weeks to, provide any backup that we can. It's important, as Tony said, and, I wanted to maybe just take a few minutes and update everyone on, kind of where we're at with asbestos litigation in the state of Illinois. And a lot of these trends apply nationally, of course. A lot of people are familiar that asbestos has been litigated, these types of cases now for, at least 40 years. And my bosses at Cooney and Conway, they started that. And when they were working up the cases back then, they had different challenges than what we're facing now today. And I wanted to just maybe touch on a few of those challenges that we deal with in our cases that might be applicable to some of the folks in the room here tonight. First of all, from a medical standpoint and a scientific standpoint, we're finding new theories used against our clients every year. A few of them I'll touch on. The one that we hear more and more often these days, it's this idea that not all asbestos is dangerous and not all asbestos causes cancer. In this country, 95% of the asbestos that was used is chrysotile asbestos that comes from Canada. And so some of these companies that have been named in the litigation, they've actually gone as far as funding studies to prove or to try and prove that, chrysotile asbestos does not cause cancer. And, that's a hurdle that we have to overcome in our cases. And it always makes me wonder if the companies are adamant that chrysotile asbestos does not cause mesothelioma, now why did all of these companies remove the chrysotile asbestos from their products? We're also facing more complex defenses, such as genetic mutation defenses. There are certainly people in this room who know more about this field than I do, but just to give a brief introduction, it's known as the BAP1 or BAP1 tumor predisposition syndrome. And what it means in a few words is that some people have a genetic predisposition to certain types of cancer, like mesothelioma. And the theory goes that it's that genetic predisposition that caused the cancer, not the exposure to asbestos. Certainly there are counter arguments to that. But the one I want to just mention is that before that defense can ever be made, it means that a plaintiff has to consent to having their genetic makeup tested. And that's an issue that's very personal to a lot of people. We all have a constitutionally protected right to privacy in our medical records and especially in our genetic makeup. So it's a challenge that, we have to stick up for our clients and make sure that, they are not subjected to that kind of testing when, frankly, they don't want to be. In the final theory that I'll just mention here tonight, it's this idea that mesothelioma is what's known as a dose-response disease, meaning that the more you are exposed to asbestos, the more likely you are to come down with the disease. And it's certainly something that's hard to dispute, but it becomes more and more important in our cases to establish that even a low level of exposure can cause mesothelioma. And the reason for that is because the client demographic is changed. Originally, the traditional asbestos clients were tradesmen and construction workers that worked with asbestos products every day for 30, 40 years. And now we're seeing more and more diverse professions and individuals getting exposed. And a lot of times they're getting exposed to a lot less asbestos, which makes that theory a lot harder for us to deal with. So, I just want to kind of leave it at that. I know we're supposed to be short and sharp tonight, but, these are some of the challenges that we're facing in the asbestos litigation. And I want to make sure I turn the mic over here to some of the other great attorneys and experts that are going to be talking to you. So thank you very much.